stapler up there, you could,
That's fine. There you go. Oh,
Slap the-
thank you. I call this meeting to order with an improvised gavel. All right, welcome to the meeting tonight, everyone. It is the Planning and Zoning Commission meeting, and today's date is November 15th. Ma'am, we have roll call, please.
Commissioner Norberg,
here.
Commissioner Kraus,
Here.
Vice Chair Bash,
Here.
Chair Keating,
Here.
Commissioner Rosenbaum,
Here.
Commissioner Smith,
Here.
Commissioner Chapman.
Here.
We have a quorum.
Thank you. Please stand and join me with the Pledge of Allegiance. I pledge
allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, thank you. Director Fitzer, we have any current events or reports?
None at this time, Chair.
All right, thank you. I do have a very short report. So as chair of this commission, I've had the privilege of attending several events. The one event that I'd like to report on tonight is I was invited to attend the interviews of 3 design firms with City Center Development Group in choosing a design firm to help them create either, I guess you could call it an updated or a current master plan for the city center. And they've the 3 firms were very well represented, 3 very good firms, and I was very happy that they wanted my input as a representative for all of you and the council as decision-making bodies. And the 3 firms were very, very impressive, and the one firm I really feel did stand out from the 3, and that is the firm that they chose. I think they've made it public, but I'll let them, make the public remarks on that. But I certainly agreed with what their decision was, and I think that we will see amazing tools used by this firm in the future to help all of us make really good, clear decisions as to how projects that come before us fit into a new master plan. And they are also continuing their public outreach meetings. The last 2 meetings that they have conducted were with Ottawa University students to get their perspective on what they would like to see and how things will work with them in the future of the city center. So that's all I have for right now. And it was a privilege and a pleasure to be a part of that interview process. Okay, at this time, I will have a call to the public. I don't see any public. At this time, is there anyone? No, there is none. We'll move on. Item number 1, Madam Secretary.
Consideration and action to review and approve or disapprove the November 1st, 2018 Planning and Zoning Commission minutes.
I move to approve.
Second.
Please vote.
Motion passes 6 in favor and 1 abstention.
Thank you. Item number 2, please.
Board of Adjustment Training.
Scroll. Okay.
All right, Ms. Van Riper, take it away.
Oh, good evening, Chair Keating, members of the commission. You have a couple of matters that are going to come before you on December 6th meeting, where you're going to act as the Board of Adjustment as opposed to Planning and Zoning Commission. And so, I guess up here, excuse me. Is that better?
Yes.
You all can hear me on that? Okay. And so, because this body has not sat as the Board of Adjustment recently, or I don't think it ever has, I'm not sure.
No.
So I figured it'd be a good opportunity to do a little primer on how, your role as a Board of Adjustment as opposed to a Planning and Zoning Commission, and how Board of Adjustment proceedings go through as far as the hearing process. So let me get this to go down. Okay. Now, under our city code, the Planning and Zoning Commission also serves as the Board of Adjustment and as the Board of Construction Review. And I think being the Board of Adjustment happened within the past few years, and I believe the City Council did this appointment of the P and Z to be the Board of Adjustment and the Board of Construction Review because the meetings were so infrequent and it was difficult to have members of the public volunteer for those boards because they rarely meet. So it got moved down to the Planning and Zoning Commission, which is actually, a good thing because the Planning and Zoning Commission is very well versed in all things involving development of the city. So it is not a bad thing to have done this. Okay. Now, before I go into the actual Board of Adjustment, I want to kind of lay some background and talk about different types of legal functions by the City Council and the Planning and Zoning Commission. As you know, the City Council acts as a legislative body. They have broad discretion in approving or denying things. The legislative function is considered more policy directed. The City Council makes final decisions on zoning changes, general plan amendments, those types of things, which are considered legislative. Now, the City Council also performs some executive functions, which are executive and ministerial in this context kind of go hand in hand, although executive could be some of the things that the mayor does on behalf of the collective City Council. Administrative things are items that the body really doesn't have much discretion to deny. The classic example is a final plat, where if the final plat presented conforms with the preliminary plat, there really isn't any discretion to say no to the approval. So you have a whole bunch of administrative functions. And I said ministerial is very routine things like approving some contracts that come forward on consent agenda. They're pretty much ministerial. Now, the Planning and Zoning Commission, probably your top duty is to be advisory to the City Council on all things that have to do with land use. You do that. You also have some administrative duties, which would be the approval of site plans and the approval of conditional use permits. And now the conditional use permits, there is a little bit of room in there for some discretion, but generally if the applicant satisfies all the requirements for that particular use permit, there's not a lot of discretion to say no. So that's the administrative. Now, to focus more on what we're here for tonight, you also have a quasi-judicial function, which you basically, as a body, act like a court and proceed like a court does. This is for both Board of Adjustments and for the Board of Construction Appeals. If we should have a Board of Construction Appeals matter come up before this body, it will proceed very much like the Board of Adjustments. So this is kind of a dual training in some respects. Okay, Board of Adjustment is a creature of statute. Very simply, by statute, the board's appointed by the City Council. A lot of jurisdictions, they appoint a separate group of individuals to serve as the Board of Adjustment, but the statute allows the City Council to can also appoint itself to be the Board of Adjustment or appoint the Planning and Zoning Commission. And Surprise has chosen to have the Planning and Zoning Commission perform this function. Board of Adjustment proceeds very much like all other public meetings in the city. You have a public notice, you have an agenda that has to be followed. So it is very similar, except this Board of Adjustment. And so what the Board of Adjustment does is basically two things. You hear and decide appeals for a zoning variance, and this is what you're going to be seeing at your next meeting, are two requests for a zoning variance as part of one case. And the zoning variances are requests for deviations from otherwise required zoning requirements. The classic examples are setbacks, building height, lot coverage. And, it's not an automatic, the applicant has the burden of proof of showing that there are special circumstances in regard to his property which do not allow him to enjoy the privileges or benefits that are enjoyed by similarly zoned properties in that same area. If, for example, if you have property that is annexed into the city under a certain zoning classification, and you end up with a lot that is undersized for that zoning classification, and you have setback requirements, or you have, lot coverage requirement, where, it's impossible for that lot in particular to develop like the other ones around it because it's smaller in size. That's an example where a variance would be appropriate because of the limitations imposed by the lot being the size it is. And now one thing, the special circumstances cannot be self-imposed by the property owner. It has to be something that is caused because of the way the lot is. It's not something that say, well, I put in my driveway here, and then, well, because my driveway's here, I can't do this, so I need a variance. Doesn't work that way. Can't be self-imposed. Now, the other thing that the Board of Adjustment hears are appeals from zoning interpretations by the zoning administrator, who for the city is Director Fitzer. And that would be, for example, something like where you have a use that's not quite, in a square box of our zoning ordinance where, well, acts mostly like this, and there are limitations. And then the property owner or an applicant can say, no, I disagree with that interpretation. And then you can do an appeal to the Board of Adjustment to have the Board of Adjustment decide the proper interpretation of a zoning requirement. So as far as the decisions that come out of the Board of Adjustment, you can grant or deny a variance application. You can affirm, reverse, or modify a zoning interpretation, but the Board of Adjustment may not change zoning or permitted uses. Those are the realm of the City Council. And so sometimes we have to be careful in granting a variance or dealing with the zoning interpretation so it doesn't move into those areas of allowing an otherwise not permitted use or affecting a zoning change. And by the statute, a Board of Adjustment decision may be appealed to Superior Court. There's some time frames for that to happen. Now, the statute, ARS 9-462.06, is pretty much mirrored by what's in our city code. Okay, now let's go over to the procedure. And I apologize for this being so dry. I'm going to try to make it a little more lively if I can. Oh, you're all smiling now. Good. Okay, so very simply, the chair of P&Z presides as the chair of the Board of Adjustment. The vice chair and the other commissioners are board members. I don't think we ever have a vice chair of a Board of Adjustment. I haven't encountered that. So Commissioner Vice Chair Bash will just be a member on the Board of Adjustment. So the board, sits for a variance, you're like a trial court. You're going to have the applicant come in and offer, being the burden of proof, they have to offer, verbal testimony, and it kind of documents that, support their position. I need a variance for this reason. That's when you're kind of like a trial court. When you're dealing with a zoning interpretation, you'll be looking at a decision already made by the director, and so you act more like an appellate court because you're going to be reviewing a lower decision. And so how this all starts is you have community development has a form for this, for requesting a variance, requesting an appeal from a zoning interpretation. And it's a written process. They fill out the form, submit it to community development, and then that starts. There's some time frames in there, start a clock. And so the written appeal is usually going to be, it's a form, and then it'll have, probably a memo attached to it, maybe copies of documents that support the application for the variance or for the zoning interpretation challenge. And then city staff will either support the variance request or not support it, or usually if it's the zoning interpretation matter, they won't support the challenge to the interpretation. And so then staff will typically prepare its own report, which will become part of the record. And that will then, go, the reports can frequently go to the board members in advance so they can read them in advance. And that's how I've done it in the past. I've had any memoranda be part of your packet, which you get, just like you do for everything else as P and Z, you get it in advance so you can be up to speed when we come to the hearing. And again, like everything else, the appeal is set for public hearing before the board. Okay, the order of the proceeding, it's kind of like a hybrid between how you normally hear things as P and Z, but then there are some things in here which are kind of more like a trial court setting. It is a hybrid. The proceeding is not as formal as a proceeding before a court like a trial. The rules of evidence that apply in a judicial setting don't apply here. There's a lot of leeway for admitting, evidence, testimony, documents. And some jurisdictions, they have the clerk swear in witnesses, but I've never, had a case where that had really had to happen. So it's basically, people, they have a duty of candor to this tribunal, especially the attorneys, being honest. And so we typically just allow people, like you have in your regular public hearings, people can come up, stand here and address the body. And if somebody has something to add to a case, they can come up and, they can present to the board. Okay, so the order of how this goes, the appellant having the burden of proof goes first, presents the case, usually with, an attorney or, the applicant himself will come up and do a, oral presentation, offer evidence being the exhibits, whatever they're going to have, and those are copies are put into the record with the clerk of the board, and then provided to the board members if they haven't been provided in advance. Then the staff gets their chance to rebut or support depending upon the situation. And then sometimes you'll have some other interested party in these kind of cases where like for example, you have a next door neighbor who, doesn't think the variance should be granted. They'll be an interested party. They'll have what's called standing to come before this body and present oral testimony evidence for that. And so once that is done, then the appellant may present rebuttal argument evidence. Again, they get the last word because they have the burden of proof. And so then after all that happens, then, the board has deliberations, just like you do on every other case. You talk amongst yourselves. During the parties' presentations, you can ask questions, while they're going along. It's very similar to what we do with, developers and their attorneys asking questions about projects. And then, but, once you close the hearing, then this board deliberates, on the dais. During that, you can ask questions of the parties. And then based upon that, then you will make a decision. Now, in advance of the hearing, as part of the staff report, you would have proposed findings of fact and conclusions of law to either support or oppose the application, depending upon the circumstances. And that's something that the board can adopt in total and not have it be its decision, or the board can say, well, we want to add A, B, C, and D, or we disagree and redo it. So if that happens, then the staff will take the record, which will be recorded and everything, and then create new findings of facts and conclusions of law, bring that back at the next meeting for consideration and approval, hopefully adoption by the board. And that would be probably, if you did something like that, you'd probably have a 6 p.m. Board of Adjustment meeting followed by a 6:15 Planning and Zoning Commission meeting. We have to have them separate, even though it's the same people. Okay, and the decision once it is reached can be appealed to Superior Court by person aggrieved, and that's just, a legalese frame word. That's usually an applicant who's been denied. Obviously, they're aggrieved. Then you have the question about, the standing question, the neighbor next door. They're considered aggrieved because they live next door, they're in close proximity. So so Board of Adjustment can have another life after this decision to go to court. Okay. So it has a couple, overarching caveats for Board of Adjustment. As Planning and Zoning commissioners, you are contacted by, developers and their representatives frequently. Members of the public will want to talk to you in advance of, your meetings. Board of Adjustment, you can't do that. You can't have what's called ex parte communications. If you're going to know you're going to be sitting as Board of Adjustment and someone reaches out to you and say, hey, I want to talk to you about this, you can say politely, I'm not unable to do so because this is a Board of Adjustment matter. Because basically it's just like a judge. Judges are can't be lobbied by litigants in a court who are involved in a court. Has to be ex parte means in secret, has to be before, in the public setting, any communications. Per the open meeting law, that also applies to Board of Adjustment. The members of the board cannot discuss the upcoming case amongst themselves. Even one or two, you really just can't do it. I would just say no discussion until we're live on the dais. Your deliberations are public. I already covered that, how it all happens, at the dais. You can ask the questions. Now, importantly, the decision that is made must be based upon the evidence that is presented. It has to be based upon testimony you hear or documents that you receive. You don't go out and do independent site inspections. You don't take some other concept in and say, well, because of this, I'm deciding this way. It has to be on the record. That's the important thing to keep in mind. And this does distinguish this quite a bit from your planning and zoning function, where you can take in account a bunch of other things that are not formally presented to the commission. Board of Adjustment is like a court. The court hears testimony, takes evidence, and decides based upon that and the law. And so we do have some standards which I've already gone over, and I could always go over, again in advance of anything as necessary. So we have the written decision prepared for board approval. And importantly, there's a written record of the proceedings that is maintained by the clerk of the board. Basically, every single document that comes in as part of the appeal is how I've done this in the past, is each one has been assembled chronologically and given a number. And then also the minutes from the meeting, the recording of the meeting all go into this record, because if you should have a court challenge, then the court is also going to be relying upon that same record to decide the appeal. So what happens is when you have an appeal filed, then the clerk of the board has to transmit the record up to the court. And so it's nice to have it with chronological itemization of what's there, and it's also presented to the parties, and who are parties to that appeal. If they disagree that something should be in there, excuse me, that was not going to be taken up before the court and not this body. Okay, what else do I have? Questions or comments time. That was good. Any questions about this? I mean, it's now also now. One thing I didn't cover is for the board. I will serve as legal counsel for the board. However, should there be a contested matter where it could possibly be that like the staff's interpretation of something could go the other way, then we'd probably retain independent legal counsel for the board, because I also represent staff and I can't represent both, especially if the board reverses the staff decision. That gets really messy for an attorney to have to be arguing both sides, especially when you go up into court. I had that happen once years ago with an attorney for a city of Cottonwood, where she tried doing that. It didn't end well. Um, so that's what we would do. And I don't know if any of you probably all know about the Winco Foods matter a few years ago, when the Board of Adjustment heard an appeal for involving the Winco Foods project. The city retained me as independent counsel for the Board of Adjustment back then, because it was so highly contested, and it was based upon an interpretation of the development agreement that was entered into for that property. And so that was fun. I can tell you some good food fight stories about that. So anyway, so do you have any questions about this?
Yes, we do have a question.
Okay.
Vice Commissioner Bash.
Yes.
Yeah, Ellen, could you discuss what our protections are under the law if, in fact, we get into a situation where it would go to Superior Court
Yes.
and you end up representing the city?
Mhm.
What kind of protections from suit do we have as commissioners in regard?
Okay. Well, you'd have, the same protections that you have as commissioners. City basically indemnifies the commissioners, and if you're on the board. But if we have a contested matter where the other party has legal counsel, et cetera, and I have to go represent staff, then your independent counsel that you had retained for the hearing would then usually would be your defense counsel at the next level. And then what I would do is, we have two attorneys. I'd be representing the city, and then we'd have independent counsel representing the board. It is weird. And I'm not going to say it's not, but that's the way it usually works.
But if it goes south, okay,
Right.
and the appellate or the aggrieved person wins the case
Right.
and decides to sue, what protections do we have as a board if there's any suit that comes out of an action? Are we covered by any insurance policy?
Oh, yeah, I said the city indemnifies, all members of boards and commissions. You're under, the city's umbrella of the protection. Now, because, also because, you're acting like a court, you get what's called judicial immunity from suit. And so that's a really high bar for a litigant to say, well, this body, all seven of you, acted badly, against the law with animus, discriminated against me, all those things. But you have that judicial immunity, and that's a great protection. Just like legislative immunity is available to the city council for, zoning decisions, general plan decisions. When you sit as Board of Adjustment, you have that judicial immunity, which is right up there with legislative.
My last comment
Yes.
is most generally what's going to be coming before the Board of Adjustment or the Board of Construction are things that have already passed by us and that we've already approved or denied in the past. I guess I just have a little bit of angst about a board that has approved or denied something being the court that is going to decide something in a definitive realm.
Okay, well, that, is a challenge in some circumstances. However, in in the case of a variance, you may have you recommended approval of, the zoning code for, certain zoning classification with setbacks and all those things. But, you have done that, but you'll be getting evidence about should there be a variance granted. So that's a little different than, you're a lot more familiar with the code in that case. And so, but you have to say, okay, well, is it, is there, special circumstances, which is a standard you don't apply as a planning and zoning commission? Is there special circumstances, or, which are sufficient to merit approving a variance? So that's a totally different function than what you do as a planning and zoning commission. Now, when you get to a zoning interpretation, that issue, it may be a little more difficult with that, because as you mentioned, you did fully analyze a zoning text amendment, for example, recommended approval to the city council. And then it's coming down to, Eric, Director Fitzer, I should say. Yeah, this Eric's good. Does an interpretation, which, property owner doesn't like, and then it comes to you. And so, although, you want to really, cut the hairs on this. I mean, you recommend adoption of the zoning change, but, how you interpret it you're a little bit of kind of cutting some hairs there, but, how you would interpret it per se is not necessarily part of that recommendation that goes forward. So
I
there is a
understand.
little bit of cutting hairs. I admit that.
I understand,
Yeah.
the city's position that these boards do not sit that often
Right.
and the difficulty in getting, and I definitely understand why the city has passed it to plan and zoning instead of city council taking the mantle of it. I definitely
Yes.
understand that. So
Yes. Okay.
that's the extent of my comments.
Okay. Yes.
If on the construction review piece, that's something that we'll probably have to convene one of those meetings over the next year. That's another item that we'll probably have to do a little bit of training on because it's a little bit different than Board of Adjustment because it's building code related as opposed to zoning code related. So that's something that we'll do another one of these on because one of the things that we will be looking at over this next year is we'll be looking at going from the 2012 international codes to the 2018. We'll be on a 6-year cycle. And that's one of those items that the Board of Construction Review would be in on, as well as something similar where there's kind of some deviations from the building code itself that that if there was an appeal that the Board of Construction Review would then have a place to hear an appeal. So
Yes, and in that case, since the Planning and Zoning Commission does nothing with the building code, then that would be a total blank slate as opposed to the Board of Adjustment. So, okay, any other questions? No? Okay, well, of course, I'm always available to answer questions. And, and then during the Board of Adjustment, hearing, if there should be a legal question presented, we can always go into an exec session, as necessary, because I will be representing the board, or if you have independent counsel, same rule applies. So, okay. Thanks,
you.
Lloyd. You're next.
Thank you. Item number 3, please.
Discussion regarding existing and future school sites.
Mr. Abrams.
Good evening, Chair, Commissioners. So, excuse me. So this update on the schools, we'll briefly go through these topics. I'll show you the map of the districts and how the city limits actually plays with each one of those. High school, touch a little bit on the attendance boundaries for Dysart. We sat and met. City coordination with the schools, and then the existing school status. Elementary school boundaries, you can see the city basically touches 5 boundaries in the future, because we'll touch Morris, the district of Morristown. We currently touch Wickenburg, Natterburg, Dysart, and a small piece of Peoria. And that's strictly the elementary. And then if we go and look, there's basically 3 high school unified districts out there: Wickenburg, Dysart, Peoria, that our boundaries touch. The unorganized areas, or the areas without the high schools, those students get to choose. Most of them choose either Dysart or Wickenburg from our planning area right now. And then here's the elementary school attendance boundaries, basically, for Dysart. And you can see we've got a big area there for Desert Oasis area, which is the Kingswood Elementary School, and then the smaller areas to include an area that the residents of Surprise go down to Luke Elementary. And then some of the coordination, every residential project, whether it's age restricted or not, goes out to each of the appropriate districts. We make sure that If it's out there in our SPA 3 area, that gets sent to Wickenburg. If it's up in our SPA 2 north of Jomax, that goes to Natterburg. And then everything else inside the city limits goes to Dysart. Met with Dysart twice this year already, talk future schools as well as school sightings and how we work with them on that. And then just recently met to take a look at what their current plans are and what they were looking at there. And right now they're looking to basically rebalance the district lines between the schools, the elementary schools. And then with Natterburg, they went forward with a bond initiative to actually start a high school program. And as it sits right now, they're about 56 votes short of getting that approved. And then, of course, we offer up the Safe Routes to School program, which we coordinate quite often, primarily with Dysart, but we're looking to work with Natterburg on the Desert Oasis Elementary School. And then as far as the status goes, Natterburg has the one school open up there in Desert Oasis, which sits up top here. And then Dysart, they have a number of schools, and they're primarily looking at how they work and what they're going to do down in this area here, as well as they're looking to get approval to open up what they call a traditional school, which basically doesn't have boundaries, but it's more a traditional setting that students have to qualify to go into. And then that would be the Kingswood Park area. At the same time, they would then look to open up the Asante School and change that program back over. The blue are all the conveyed properties, and the yellow that you see, which you can see where we've approved a few developments up here in the northeast corner of the city. For Rancho Mercado, they have 2 proposed sites. There's another one in Asante. One's been agreed to in Asante. And then you have 2 proposed, which is in the Zenjero Trails area. And up north in Zenjero Trails, they have also conveyed one. And that, I'll take any questions.
All right, does anyone have any questions? Commissioner Norberg.
Can you actually go back to that previous
Sure.
one? I was just taking a look at the high schools that they have there. If you could just keep it up there, I don't really have any questions. Thank you.
Yeah. So you've got the Dysart High School, which isn't shown on the map, and then you've got the Willow Canyon, Verde Vista, and Shadow Ridge.
On the high schools, you had mentioned, or for the elementaries, you had mentioned that they're thinking about doing redistricting. Did they say anything about redistricting for the high schools?
Not at this time.
This time?
Yeah, and they're looking at more or less just trying to balance, because as each development ages, the enrollment goes down, so they're trying to balance each of those and how to reuse those existing facilities.
Okay, thank you.
Great. Commissioner Rosenbaum.
I'd like to thank all your effort in doing this. I appreciate that. When we're approving a few thousand additional homes, it's nice to know that the districts have a plan in place. So thank you very much.
So,
All right, I don't see any other questions from anyone. Thank you, Mr. Abrams. All right, item number 4 would be discussion regarding direction pertaining to any future agenda items. Does anyone have anything to bring up for the future? No? Great, seeing none, then I adjourn this meeting.